Minister of Constitutional Affairs, and the Minister of and the Attorney General, and then the National Coffee Amendment Bill 2024, pending debate. Today we will commence the sitting with the two. Can we start with the tribunal? Honorable members, you'll allow me to vary the order paper and accommodate the report from the minister, from leader of opposition on Biofarm Limited. Leader of opposition. Sechi.
Thank you, Right Honourable Speaker. Right Honourable Speaker, I rise.
Welcome back.
Most obliged, Right Honourable Speaker. Right Honourable Speaker, I rise on a matter of great public importance. You know we belong to the Commonwealth, and we are duly represented as part of the Commonwealth community. But Right Honourable Speaker and members, as you are aware, the CHOGM meeting, the Commonwealth CHOGM meeting, opened in Samoa, a Pacific island, yesterday. And as Uganda, we've been chairing, and the last season we hosted. But apparently no statement is being made about our participation as a country. We read in the statements about you being stopped from attending the Commonwealth, but we are the Parliament of Uganda. Does that also stop the Parliament of Uganda from participating in the Commonwealth?
Which meeting of Commonwealth have I been stopped?
No.
I am actually going for Commonwealth meeting tonight. I am a chairperson of the Commonwealth speakers. I'm a chairperson.
Yes.
Our next meeting that we have is in India. So the one of Samoa is CHOGM, that is being attended by the Vice President of this country, representing the President. The Speaker was not part of it. That is for presidents. CISPOC is for speakers, which I am going for even tomorrow. CHOGM is for the heads of state. I just want when say tomorrow when you become a president, that is the one you'll be attending. For us, the small people, we attend the other ones.
The Speaker was to inquire whether a delegation has been.
No, there's a delegation. There's a delegation there from from executive. Actually, I need to go with I need to add the search in my delegation for CISPOC. No. For CHOGM, it is a president.
but Speaker.
It is a president to add you.
But Madam Speaker, I've not been traveling, and I don't think I would be in position to travel. I still have business here to do.
Okay. Thank you.
Madam Speaker, thank you very much. On the same point that the Honorable Sechikubo makes, we had UN General Assembly recently, and the President was represented by the Vice President. We had a meeting in China, and again our President was represented. You have just said even for Commonwealth. I did ask here, Madam Speaker, and this Parliament may not have taken it seriously, the need to check on the health of our President because of his age. All these important meetings that he has been attending traditionally, he now can't attend, and you're saying order.
Honorable
So
members,
the
honorable members, that is the benefit of having a deputy. Why don't you complain when my deputy is chairing here? And I mean, you delegate. And as far as I know, President Museveni may even be more healthier than some of us.
I agree entirely. But when it becomes a tradition, for example, the Minister of Education never attends Parliament, I have every reason to keep asking. What is so special that a Minister of Education cannot attend? What has happened to the President who was representing Uganda to the General Assembly, to meetings of heads of state in China, now to Chogam, that he cannot attend every meeting? He must be represented.
We passed the rules here that you can participate on virtually, and I've always seen Honorable Kataha online. Even now she's online if you want to when we have an issue on education, she will address us on education. So, but for now, let's first listen to the leader, Right Honorable Leader of Opposition. Leader of Opposition.
Thank you, Right Honorable Speaker. I am happy with your guidance that we are able to ask questions to colleagues who are not in the House, especially ministers, because many times we look for them. Now that they can also respond to us when they are online, we do take your good guidance. We shall keep shooting those questions and require that those ministers respond to our questions even when they are online. So I want to thank you for that guidance, Right Honorable Speaker. We are going to act on it. You can be very sure, Right Honorable Speaker, because the ministers we always look for and we do not get them. But now that they are online, we shall find them online. This is the technology age. Some colleagues are saying, even in their offices, this is Parliament. We require you people here in Parliament, so that you account not just to us, but to the people of Uganda. So when we come to your offices, it's okay. A member can pay a courtesy visit. I can go to Ladit's office. But when I have certain critical questions on behalf of the people of Uganda, Ladit should be here and he should account. But let me move away from that issue, Right Honorable Speaker. Via Rule 53, Right Honorable Speaker, I would like to present this very quick report on an oversight visit that, together with some colleagues, we did pay to vote 167, that is Science, Technology and Innovation, to support what was called Strategic Pharmaceutical Industrial Investment, and particularly Day Biofarm Limited. In fulfillment of Section 6A and E of the Administration of Parliament Amendment Act of 2006, I led a delegation of some members of the Shadow Cabinet to visit Day Biofarm Limited on Thursday, September 19th, 2024, with the objective of establishing value for the taxpayer money invested in this company and assessing progress of operations of this company. Day Biofarm Limited, a drug and vaccine manufacturing plant, is located at Matuga in Wakiso district, and its director is a one Mr. Matthias Magola. This pharmaceutical company was launched on July 6, 2021, and it set out to produce all forms of essential medicine, including vaccines. Mr. Magola came into prominence in March 2020, following his claims to have discovered a cure for COVID-19. He promised to produce medicine for COVID, but that never saw the light of day, Right Honorable Speaker and members. To date, Day Biopharma has received a cumulative total amount of 723.4 billion shillings in funding from government. 723.4 billion shillings. This financial support began with an initial allocation of 70 billion, which was granted during financial year 2023-2024, followed by an additional 75 billion in December of 2023, and finally the most recent significant amount of 578.4 billion that was provided through the supplementary schedule you have talked about. The bailout money was intended for government to acquire equity and become a shareholder. However, the funding allocated to Day Biopharma became contentious during the parliamentary discussions, with the minority report raising multiple concerns, which included: 1, lack of evidence of a special board resolution granting government shares in this company. 2, there was no evaluation and valuation of this company by the chief government valuer to ascertain the company's worthiness and viability. 3, there was no memorandum and articles of association to establish the actual owners of the company. There was no disclosure of beneficial owners as a new requirement in the Company Act to curtail money laundering. And 5, there was no memorandum of understanding or agreement spelling out key obligations. And these are questions we asked on that day in this House, Right Honourable Speaker. Government promised that after the supplementary request gets approved by Parliament, they would set out to do all that due diligence. This position was not tenable to a number of us in the House because we did not want to put the cart before the horse. We told government that availing money to a company whose worth is not ascertained is like shooting first and aiming later. Despite our concerns, the supplementary request was approved. The delegation of legislators that I went with interacted with members of the board and management, who provided some insights into the company's initiatives and challenges. They offered perspectives on regulatory, compliance, and pharmaceutical practices, including research developments and production capabilities. The objectives of our oversight visit included assessing the progress of setting up the plant and establishing whether there was value for taxpayers' money thus far. 2, to verify whether there was progress regarding Day Biopharma Limited's pledge to manufacture vaccines and other essential medicines. 3, to ascertain the extent of the government's shareholding in Day Biopharma Limited. And 4, to determine if a proper valuation was conducted and whether an agreement exists between the government and Day Biopharma Limited. Our findings, Right Honourable Speaker: management asserted that Day Biopharma had been valued and that an agreement had been signed with government. However, they did not present any documentation to substantiate this assertion. Government should avail to Parliament all documentation regarding the said agreement with Day Biopharma and the valuation of the company, if at all these documents exist. 2, while it was noted that the infrastructure was in place at the time of the visit, what Ugandans are interested in is the promised production of essential medicines and vaccines. Management of Day Biopharma assured the delegation that medicine production was going to commence at the start of October 2024. Right Honourable Speaker and colleagues, we are now coming to the end of October. Can government provide an update on this matter? 3, interestingly, when pressed for speedy delivery and production and subsequent accountability for government funds, the proprietor expressed readiness to refund the 723.4 billion to government soon. Can government elucidate on this issue? We've made 3 recommendations. The government should provide accountability for the 723.4 billion already spent on this project. Would like to see value for taxpayers' money. 2, to promote transparency, the government should be able to table on the floor of Parliament the agreement signed with Day Biopharma to ascertain obligations of each party and the valuation report by the chief government valuer. Let them be tabled here on the floor so that we know. 3, government should bring to Parliament a comprehensive policy on bailouts to guide future government interventions in private enterprises. This will help to determine objectively which companies are deserving of bailouts and how struggling companies can be able to apply for bailouts. As it is today, it seems that only those who are connected to people in government are able to access bailouts. No wonder a number of them don't feel obliged or obligated to account for the funds that they receive. In conclusion, Right Honorable Speaker, the lack of transparency surrounding the agreement between the government of Uganda and Biofarm raises considerable concerns about the accountability of both parties involved. We don't know why government is leaving a lot of room for suspicion. Keep us in the loop. Table the agreements. Let us know what's happening. Relatedly, it is prudent that before any financial commitment by government to a company, there must be due diligence done before, not after extending funds. Let me repeat that, Right Honorable Speaker. Before any financial commitment by government to a company, there must be due diligence done before, not after. Because when we were here debating this matter and saying, where's the due diligence, government was telling us, we are going to carry it out. So why then do you want us to extend money when we have not done due diligence? Let's be better organized. Let's stop being shabby. It is imperative for government to prioritize accountability in all public expenditures, particularly in high-stakes commitments such as this one. Finally, let me reiterate that establishing a comprehensive policy regarding company bailouts must be in place in order to avoid ambiguities in future dealings. Such a policy would provide clear guidelines and criteria for when and how public funds can be used to support private enterprises, ensuring that taxpayers' interests are safeguarded and that all actions taken are in the best interest of the public. This approach would not only mitigate potential risks, but also ensure that government is committed to transparency and fiscal responsibility. Right Honorable Speaker and colleagues, I beg to submit. Thank you.
Thank you so much, Honorable Leader of Opposition, and as still say, the Attorney General, together with the Minister of Finance, will give us a written response to Lob's findings.
When we are passing the supplementary budget for day, the condition by Parliament and government undertook that they will not release money until we have acquired shareholding in that company. Madam Speaker, I am reliably informed that as soon as we appropriated, actually money went. Even as I speak now, we have not acquired the shareholding in that company. So as they come to respond to the issues that the Leader of Opposition has raised, can they also lay on table a share certificate and
Yes.
And when they acquired those shares, Madam Speaker?
Yes, that should be included in the report. And we are not going to discuss this report. We will discuss when the two reports together, when the other one comes. Next item.
Item 3 on the order paper, Bill second reading, the National Tribunal Bill 2024.
Honourable members, pursuant to Rule 130 of the Rules of Procedure, I now invite the Minister of Constitutional Affairs to move a motion for the second reading of the bill. Yesterday, this bill was stood over because the Minister was not in. Now that the Minister is around, could you move a motion? Procedure.
Thank you, Madam Speaker, for the opportunity. Madam Speaker, I want to make the observation and then I raise my procedure issue, Madam Speaker. Madam Speaker, we have handled bills on rationalization. And rationalization, Madam Speaker and colleagues, when you look at the meaning, scientific meaning of rationalization, we are talking about reorganization of an organization or a company. We are talking about streamlining, and we are talking about restructuring. And when you look at these three terms, Madam Speaker, rationalization is a process. It is not a one-day thing or a full-stop thing. So, Madam Speaker, my concern, this being a process, as we talk about this process, I think procedurally we should have a time frame when the commencement of this process should start. Because when you look at what is happening now, since this process started, most of the employees of these organizations under rationalization, they are in shadow about the future of what is likely to happen. Madam Speaker, there are members of staff in these organizations who are on a contract basis. Some of them, their contracts are ending, some of them still have running contracts. So if we make a law and we not put a commencement date, then I think there will be a problem in this process. Finally, Madam Speaker and colleagues, when we pass resolutions here as Parliament, and there is some that backfire, it comes back to us. There is a recommendation here which we passed about the science teachers on their enhancement. And Madam Speaker, as I speak now, and I have information here, over 5,000 teachers have applied for the early retirement. Now, instead of now thinking about the arts teachers, the president, when he was attending the Teachers' Day, he's now giving a directive.
How are you bringing that?
Now, why I'm saying this, Madam, is that we must be very cautious when we are making these laws. We should not rush to make a law without a commencement date. All these bills,
But
I know
the
it
issue
was
of the
deliberate or not.
commencement date was handled yesterday.
Madam, it should be clear on our side as Parliament that this process should commence after a specified period. Otherwise, if we leave it the way it is, we're going to have issues, Madam Speaker.
Honourable members, as we have the laws, we can have a close commencement date. Then we will look at it clause by clause. Honourable Minister of Constitutional Affairs, you people, you want to continue?
Right Honourable Speaker, the last 3 days we have been enacting very important laws for the people of Uganda, but I notice the absence of the Attorney General and the Deputy Attorney General.
Their boss is here.
Yes,
Minister of Constitutional Affairs.
He's a minister, but not the Attorney General. The two are very different. How can we enact law? How can we pass legislation without the input of the Attorney General? Even the Deputy Attorney, they are not here. Right Honourable Speaker. Are we proceeding well?
Honourable Constitutional. And may I have my Shadow Attorney General there, Honourable Katuntu, for independence. Yes, you're answering where your team is. Let him first answer where is his team.
Madam Speaker, we have got one government and we also have skills. I wish to inform the House, as indeed the Government Chief Whip did, that the Attorney General is in Washington, D.C. in a meeting of the World Bank, which is very important for the development of this country. We are in touch with him, and should there be any need for any consultation which requires him in his constitutional capacity, we can reach out. The Deputy Attorney General is in the Gambia also to represent our country in a meeting. And as we talk now, I am exercising the functions of the Office of the Attorney General. Madam Speaker, I'm an advocate of the courts of judicature, having been entered on the roll in 1994.
Thank you. Thank you.
Right Honourable Speaker, I may not rejoin on the statement of the Honourable Minister for Justice and Constitutional Affairs. I have my own reservations because the other two are constitutional offices that demand the reconsideration of my senior in the profession in that regard. His position, he may have to reconsider it, but mine, Honorable Tungo raised a very important matter, and you have not guided on the same, about the 5,000 teachers. No, about the 5,000 teachers.
No, it was smuggled in it. I don't know about it. I have not heard about it. So how do I answer what I don't know? Maybe let the Minister of Education respond to that. Yes. Minister of Education, handle. No, I can't answer what I...
Madam Speaker, first of all, apologies for coming in late. But I will be interested in, Madam Speaker, if you permit. I don't know which source Honorable Itungo is quoting that the 5,000 teachers are planning to retire. But even then,
Madam Speaker, with your permission, can I lay on the table?
What are you laying on table?
Madam Speaker.
What are you laying on table?
I need to recollect very well on the rule.
What are you laying on
whether
table?
The rule permits us to lay a newspaper onto a table for purpose of it being a record of any business of Parliament. And I need first the government chief whip to help me. However, friends, let's get to the facts.
We are now on a fishing expedition.
Friends, let's get to the facts. First of all, a retirement is an individual's need. Even me today, if I was a public servant employed by government, I can afford to ask for an early retirement. Number two, Madam Speaker, can I be protected? Number two, if anyone has asked for an early retirement, I want to confirm this. We have quite a number of young people in this country who are qualified to teach.
Thank you, Right Honourable Speaker.
I thank you
for the opportunity. Yesterday you guided us very well when we had a response from the Minister of Education. Yes. And you gave opportunity to the team of LOP, the minister, the shadow minister under LOP, to prepare so that the LOP presents their position and we have a debate after hearing from that side. So are we right today again to start to debate this matter when LOP was not yet presented the report we resolved on yesterday?
LOP include what has been raised by Honorable Bigaba, by Honorable Nathan, to your report, and you present it together. Honorable Minister, move a motion.
Thank you, Madam Speaker. First, I wish to offer my apology for being absent yesterday. I was summoned.
Honorable Okoto Gong, there is one house here.
Madam Speaker, I was summoned to go for
Can
a
you
hearing.
move a motion?
So I beg that my apology be accepted.
Your apology was already accepted.
Thank you, Madam Speaker. I beg to move, Madam Speaker, that the bill titled the National Tribunal's Bill be read a second time. I beg to move, Madam Speaker.
Is the motion seconded? Seconded by Honorable Guang, Honorable Gidudu, Honorable Honorable Musasizi, Honorable Bright, Honorable Chairperson of Legal, Honorable Prime Minister, Government Chief Whip by the whole side, and Honorable Minister of Public Service, local government, Honorable Rusoke, by the whole army, by Mpindi, by Honorable Okelo, Honorable Okelo, Honorable Koluo, Honorable Kot, Honorable Atima Peya, Honorable Bish, Honorable Milton. Thank you. Would you love to speak to your motion?
Madam Speaker, when I joined the government, I found the declared policy of rationalization. I addressed my mind to its major objectives, and I formed the opinion that it will not displace the services that are intended to be performed for the citizens of Uganda. So, because of that, the dissolution of these agencies have been titled rationalization, with the intention of ensuring efficiency and saving money. Secondly, to achieve that, some laws have to be amended. Amended by repeal, and in some cases, by consolidation. It is not necessary for me to go into the big details. Suffice it to say, Madam Speaker, that one of the key roles of government, apart from the other three, of ensuring the territorial integrity of the country, ensuring that citizens are safe, and enacting laws and regulations, another key function is adjudicating disputes on what the laws actually mean. And for that reason, we have the courts of judicature, we have got tribunals, we also have quasi-judicial bodies. So we bring this bill so that citizens, when they disagree with the state on what the law says, particularly on matters such as taxation, such as the pricing for services, for instance, electricity, there is a body that can speak unequivocally about what the law actually means. As long as there is life on earth, there will always be disputes. And therefore, we need a body with qualified men and women to listen to the contending sides and to determine what the law actually means. That is the reason for the National Tribunal Bill. This National Tribunal Bill, according to the details, will be able to settle all sorts of disputes, and after engaging with the committee, we believe that the body will ensure harmony. Lastly, Madam Speaker, the National Tribunal Bill is dissolving the Tax Appeals Tribunal, which has been one of the bodies. As you know, when you go to the chapter on finance, the first sentence actually deals with taxes. Sometimes the state oversteps the boundaries of its powers, so citizens must have a recourse where they can go and get justice. There will also be disputes relating to procurement. There's a lot of rivalries on whether procurement processes are fair, whether they adhere to the law. The National Tribunal will also be dealing with that. So, we do not have any major rope pulling with the committee. From my experience, this is one of those bills which is totally uncontroversial, because citizens will continue to be served and to get justice whenever they are disagreeing with the state or any agency on what the law actually means. So, without wasting time, today I am here to work with the Parliament of Uganda based on a process of cross-pollination. This bill, I can assure you, has been pollinated by the representatives of the people who sit in this august house, and Ugandans will be happy that now they have one address where to take their issues whenever they disagree with the state. Thank you, Madam Speaker. I urge members to support this bill.
Thank you so much, Honorable Chair. You can now present your report. I am also informed there's a minority report.
Thank you, Right Honorable Speaker and honorable members. I've laid on table a copy of the report, the minutes of the meetings that we had with the stakeholders, copy of the minority report, and the stakeholder memorandums that they presented to us. It's laid on table. Right Honorable Speaker and members, this is a report of the Sectoral Committee on Legal and Parliamentary Affairs on the National Tribunal Bill 2024. Madam Speaker, I'll beg your indulgence. It is a bit lengthy, but since there wasn't controversy, I'll keep skipping some paragraphs which are not so crucial, although members, I'm sure, they have read, because this was uploaded on our platform, I think 2 days ago. On 24th, 2024, the National Tribunal 2024 was read for the first time and was in accordance with Rule 129 of the Rules of Procedure, referred to the Committee on Legal and Parliamentary Affairs for scrutiny, in accordance with Rule 129 of the Rules of Procedure of Parliament of Uganda. The committee has examined the bill and hereby presents its report. Overview of the National Tribunal 2024. The policy behind the bill is to give effect to the policy of rationalization of government agencies and public expenditure, which was adopted by the Cabinet on 22nd February 2021 and is contained in Cabinet Minute number 43, CT 2021. The object of the National Tribunal Bill 2024 is to establish the National Tribunal and for related matters. The National Tribunal is intended to replace and carry on the functions of the Tax Appeals Tribunal established by the Tax Appeals Tribunal Act, Cap 341, the Electricity Disputes Tribunal established by the Electricity Act Cap 157 and all other tribunals established by law, as it has been provided under Clause 16 and 42 of the bill. The rationale for establishing a single tribunal to carry out the functions of all other tribunals in Uganda is to ensure the resolution of disputes arising from the implementation of different acts by a single tribunal in order to reduce on the administrative costs incurred by government. The bill therefore proposes, and the proposals in the bill have been talked to by the minister. I will skip that and go to page 3, paragraph 3.0, which is methodology. In the process of analyzing the bill, the committee met and held discussions with the following stakeholders: the Ministry of Justice and Constitutional Affairs, the Uganda Law Development Center, the Tax Appeals Tribunal, the Electricity Disputes Tribunal, and reviewed the following relevant documents: the Constitution of the Republic of Uganda, the Tax Appeals Tribunal Act Cap 345, the Electricity Act Cap 157, Oxford Learners Advanced Learners Dictionary, 6th edition, court decisions, administration of the Judiciary Act, and Cabinet Minute number 43, CT 2021. Now, the next paragraph 4.0 is about tribunals in Uganda, and the import there basically is to define tribunals. And what I can see there is on the second paragraph on page 4, which says that by nature of their tribunals are created by statute, exercise quasi-judicial functions, and carry out their duties in accordance with the law under which they are established, and principles of natural justice. Usually, tribunals are set up to handle administrative issues that cannot be handled conveniently by the ordinary courts. Tribunals are usually set up to resolve disputes between public authorities and individuals that may arise in the course of implementation of policies or enforcement of laws. Currently, there are a number of tribunals created in pursuant to provisions of the Constitution of the Republic of Uganda, 1995, and other tribunals created through other enactments of Parliament. And here below, we bring for you the constitutional tribunals enacted by command of the Constitution, and then constitutional tribunals that have been enacted by an acts of Parliament. That is page 4. Then we go to page 5, and then we go straight to page 7. Let's go to page 7 and see what is there. Now, page 7, we go to general analysis, observation, findings, and recommendations of the committee. This part is of analysis. This part of the analysis examines the bill and considers the provisions being amended, the proposed amendments made to the provision, the effect of the amendments, including the provisions' legality, effect, and effectiveness in light of other provisions or any other law, existing public policy, if any, court decisions, and mischief it intends to cure. The analysis is classified in thematic areas the bill proposes, after which a recommendation is stated. The matters are divided into preliminary matters and substantive matters raised by stakeholders during their interaction with the committee. Now, under preliminary matters raised by the stakeholders and members of the committee, there arose the issue of constitutionality of the bill in light of Article 152. And I want to read this one, Honourable Speaker, for the members to understand, because it is a matter of contention by the minority report. During the consideration of the report, a number of preliminary matters were raised relating to the constitutionality of the bill, public consultation, application of the bill, and the policy considerations and other matters which are highlighted below. Constitutionality of the bill in light of Article 152. Stakeholders raised the preliminary matter relating to the constitutionality of the bill in regard to the proposal to merge the Tax Appeals Tribunal with the Electricity Disputes Tribunal. The proponents of this objection argue that the proposal to merge the Tax Appeals Tribunal with any other tribunal as proposed in the bill will infringe Article 152 of the Constitution. According to the proponents, Article 152(3), Clause 3 of the Constitution envisages an independent Tax Appeals Tribunal whose only role is to settle tax disputes. They further urge that the Tax Appeals Tribunal cannot be merged with any other tribunal and should remain independent with a single mandate to settle tax disputes. The committee has examined the assertions made by the stakeholders and members of the committee, find no merit in them. In arriving on this finding, the committee examined Article 152 and found that the bill in its current form does not infringe any constitutional provisions, especially Article 152 Clause 3 of the Constitution, as alleged. Article 152 is reproduced below, and Article 152, the head note is taxation. No tax shall be imposed except under the authority of an act of parliament. That is Clause 1. Clause 2, where a law enacted under Clause 1 of the article, of this article, confers powers on any person or authority to waive or vary a tax imposed by that law, that person or authority shall report to Parliament periodically on the exercise of those powers as shall be determined by law. Now, Clause 3, which is the matter of contention. Parliament shall make laws to establish tax tribunals for the purposes of settling tax disputes. The committee finds that Article 152, Clause 3, imposes an obligation on Parliament to establish tax tribunals for purposes of settling tax disputes. The provision requires the establishment of tax tribunals and the settlement of tax disputes by tribunals as so established. This provision merely obligates Parliament to provide a mechanism for settling tax disputes. The mechanism must be a tribunal and not a cohort of judicature or any other forum. The provision does not require that the settlement of tax disputes must be done by a single tribunal whose only function is to adjudicate on tax disputes, as alleged by the persons objecting to the bill. Indeed, Clause 3 of Article 152 is crafted in plural and envisages the appointment of more than one tribunal for settlement of tax disputes. The provision does not also require that the name of the tribunal envisaged in the provision be Tax Appeals Tribunal. The committee finds no cap on the jurisdiction that may be exercised by the tribunal created pursuant to 153 Clause 3 of the Constitution. The tribunal envisaged under Article 152 can handle tax disputes and any other disputes that Parliament may confer into it. And the argument proceeds, but that's the crust of it. The recommendation that the committee recommends that the argument that the bill infringes Article 152 be rejected. Policy considerations. The committee also received submissions from a number of stakeholders whose opinion was that the bill is premised on a wrong policy, since the cabinet decision taken on 22nd February was contained in cabinet minute number 43, did not recommend the merge of Tax Appeals Tribunal with the Electricity Disputes Tribunal, as alleged in the memorandum of the bill. The proponents of this argument opine that the bill is hinged on a falsehood, since the cabinet has never recommended the merger of Electricity Disputes Tribunal with the other tribunals in Uganda. Our finding is that RAPEX is a government policy as passed in the 2021 Cabinet Minute Extract, which I have given you, and therefore we find no merit in this argument. We recommend the committee recommends that the assertion that the policy for rationalization of government agencies and public expenditure does not extend to Electricity Disputes Tribunal is rejected. Consultations of affected tribunals. Various stakeholders made the assertion that government did not consult them, or that the consultations were insufficient, or that their views were not taken into consideration during the consultation process, leading to the introduction of the bill. The committee was informed by the representatives of the Tax Appeals Tribunal and then members of the Electricity Disputes Tribunal that whereas they were consulted during the formulation of RAPEX policy, their views were not taken into account. The committee was informed that Tax Appeals Tribunal and the Electricity Dispute Tribunal were both objected to the merger, but these views were rejected by Cabinet. In responding to this matter, the committee is aware that Article 1 of the Constitution guarantees the sovereignty of the people of Uganda. The committee is also aware that there is no legal requirement for public consultation because during the conceptualization of policy laws, and similarly good governance and good practice to consult the public. All there is in the Constitution on public participation is in the national objectives and directive principles of state policy, and the provision of Constitution for a bill to be sent to the committee for conducting a hearing. In the absence of a law that lays down a structure modus operandi for public consultation and participation, the committee is aware and was informed that the government consulted widely the affected agencies, and some indeed submitted their views and responses to the proposals to the bill. the committee was informed that indeed the Tax Appeals Tribunal and the Electricity Dispute Tribunal views were sought on the proposed merger through the aligning ministries, and we are informed that the decision to merge them had been made by Cabinet. And so we conclude that the committee is satisfied that there was sufficient consultations carried out by government during the conceptualization of the RAPEX policy application of the bill. Various stakeholders opined that the bill should be rejected on grounds that its application is not clear and it infringes on various articles of the Constitution, since it rationalizes various tribunals established or envisaged in the Constitution. The committee has examined this assertion and finds that whereas the bill does not clearly stipulate the tribunals it seeks to rationalize, save for the Tax Appeals Tribunal and the Electricity Disputes Tribunal, this is not a ground for total refusal of the bill in its entirety, since the Committee of Parliament are empowered under Rule 129 to propose amendments as the committee deems necessary. The committee notes that the explanatory memorandum states that the intention of the bill is to merge tax appeals and electricity disputes tribunal into one tribunal called the National Tribunal, which shall adjudicate all disputes subject to a tribunal. But clause 43 and 44 of the bill, and clause 43 and 43 of the bill emphasizes this intention by repealing the Tax Appeals Tribunal and dissolves the Electricity Disputes Tribunal as well. That as it may, clause 43 suggests that the intention of the bill goes beyond just merging those two agencies. Clause 43 provides that where any act provides for the establishment of a tribunal, the National Tribunal shall be taken to be the tribunal established by the act. Clause 43 has the effect of transferring the functions of all other tribunals envisaged or established under any act or under any other law to the National Tribunal. Similarly, clause 16 of the bill can be interpreted as extending the jurisdiction of the bill to tribunals that are established under any other act of Parliament. The committee has examined the bill and other relevant laws applicable to the subject matter and is of the considered opinion that the confusion as to the application of the bill and the proposed extension of the bill to all other tribunals directly established or envisaged under other laws has constitutional and legal ramifications, which might affect the legality of the bill if not amended. The first challenge will be constitutional, since clause 42 will have the effect of amending the Constitution to transfer the National Tribunal to the functions of all tribunals created and envisaged under the Constitution. It should be noted that the Constitution creates directly or empowers the establishment of the following tribunals. We list the tribunals that are established under the Constitution. For example, there is a tribunal appointed by the President under Article 60 of the Constitution for the removal of a member of the Electoral Commission. There is another tribunal, for example, established by the Chief Justice under Article 64 of the Constitution to hear and determine a dispute between the Electoral Commission and any other person aggrieved by a decision of the Electoral Commission in respect of demarcation of constituencies. And we list all the constitutional tribunals envisaged under the Constitution. Now, clause 42 appears to suggest that the above tribunals created or envisaged under the Constitution will be dissolved and their functions taken over by the National Tribunal. If this is the intention of clause 42, then clause 42 amends the Constitution indirectly, a matter that will open the bill to legal challenge for contravening Article 259 of the Constitution. It is therefore the committee's considered opinion that unless clause 42 specifically exempt constitutional provisions from the application of the bill, clause 42 is likely to be challenged for contravening all articles of the Constitution that directly create tribunals or provide for the appointment of a tribunal in specified circumstances. And so we propose that this bill restricts itself to tribunals that are not envisaged under the Constitution as we have listed them. They are listed here. The Tax Appeals Tribunal, and then we have the Public Procurement and Dispose of Public Assets Appeals Tribunal established in Section 108 of the Public Procurement Dispose of Public Acts. The Electricity Disputes Tribunal established by Section 97 of the Electricity Act, Cap 157. The Insurance Appeals Tribunal, continued in existence under Section 135 of the Insurance Act, Cap 191, the Uganda Communications Tribunal established under Section 61 of the Uganda Communications Act, Cap 103, the Retirement Benefits Appeals Tribunal established under Section 83 of the Uganda Retirement Benefits Regulatory Authority, Cap 232, the Capital Markets Tribunal established under Section 131 of the Capital Markets Authority Act, Cap 64, the Seeds and Plants Tribunal established under Section 16 of the Seeds and Plants Act, Cap 41. And our recommendations that the committee recommends that the bill should be amended to restrict the application of the bill to tribunals created under acts of parliament other than the Constitution. Substantive matters, page 15, substantive matters on the contents of the bill. Those were preliminary matters. Now, the issue of mergers. The intention of the bill is twofold. The first intention is, as communicated by the memorandum, and clause 43 and 44 is to merge the Tax Appeals Tribunal and the Electricity Disputes Tribunal into one national tribunal called the National Tribunal, which shall adjudicate all disputes subject to settlement by a tribunal. The second intention is to abolish all the other tribunals in Uganda and transfer the functions that have hitherto been performed by all other tribunals to the National Tribunal. This intention is communicated by clause 42 of the bill, which is to the effect that where any act provides for the establishment of the tribunal shall be taken to be a tribunal established by the act. This, in essence, rationalizes all other tribunals in Uganda. The tribunals affected by the bill, I've already listed them. I've already listed the tribunals that are going to be affected by the bill. So I will go to page. I'm now on page 18, and our decision on mergers. The committee received the views and opinions on the proposal to merge the tribunals. Those in support of the proposal aver that the merger will relieve the government of financial drain in its resources and the burden of wasteful administration and expenditure, and facilitate efficient and effective service delivery and promote coordinated administrative arrangements, policies, and procedures. Those who are opposed to the merger aver that the energy policy of Uganda, which proposed the establishment of Electricity Tribunal, supersedes the RAPEX policy, and that the Electricity Disputes Tribunal is a key component of the electricity sector and deserves to be left as a standalone. The other issues raised include disruption in the performance of the mandates of the tribunals, mismatch in the mandates of the different tribunals being merged, limited number of members at the proposed National Tribunal, and restrictive qualifications and experiential requirements for entities that are merging. And our recommendations in respect of that is that in light of the above, the committee recommends that the following tribunals be merged into the National Tribunal. And these ones, I'd already mentioned them, but let me just mention them to be very specific. The Tax Appeals Tribunal established under the Tax Appeals Tribunal Act, the Electricity Disputes Tribunal established by the Electricity Act, the Public Procurement and Disposal of Public Assets Tribunal established under the Public Procurement and Disposal of Public Assets Act, the Insurance Appeals Tribunal established under the Insurance Act, the Uganda Communications Tribunal established under the Uganda Communications Act, the Retirement Benefits Appeals Tribunal established under the Uganda Retirement Benefits Regulatory Authority Act, the Capital Markets Tribunal established under the Capital Markets Authority Act, and the Seeds and Plants Tribunal established under the Seeds and Plants Act. In addition to that, the appointment of members of the National Tribunal should take into account the need to have persons qualified in the subject matter of the tribunals, so that the National Tribunal is constituted by persons who have knowledge in the broader subject matter of the National Tribunal. The other issue is qualifications for appointment and duration of service. And this is critical. I'll read it because members need to understand our proposal here. In clause 5 and 6 of the bill prescribes the qualifications and terms of service of a member of the tribunal. Clause 5 requires the person that may only be appointed as a member of the tribunal if the person is of high moral character and proven integrity and has not been convicted of any offense involving moral turpitude. The provision further requires that the member must possess qualifications in taxation, finance, accounting, or law, or such other qualifications the minister may by statutory instrument prescribe. Clause 6, on the other hand, provides that the chairperson and other members of the tribunal serve for 3 years and are eligible for reappointment. The committee has examined the proposals contained in Clause 5 and 6 and it is of the considered opinion that some of the aspects contained in the provisions need to be rethought. For instance, the proposal to bar persons who have been convicted of any offense involving moral turpitude should be rethought, since the offenses falling under the category of offense involving moral turpitude are difficult to determine. Using the phrase moral turpitude will affect the effectiveness of the provision, and since such offenses involving moral turpitude cannot easily be defined and determined. And we go on to say it should be noted that whereas the phrase moral turpitude, our argument here, honorable members, is that we seek to omit the requirement that we seek to remove the idea of excluding someone on the grounds of moral turpitude, because their definitions have been problematic in the courts of law. And our recommendation is that offenses involving moral turpitude in Clause 5 should be deleted, and in Clause 6, the provision should be amended to impose term limits. And then on the issue of term limits, the proposal was that a member could be appointed for 3 years and then reappointed without putting term limits. We are proposing that members of the board be appointed for only 3 years with a further term of only 1. So we are putting a term limit. Page 23, appointment of the judge to the tribunal and effect on his or her tenure as a judge. Clause 3 of the bill provides that the chairperson of the National Tribunal provides for the chairperson of the National Tribunal and requires that he or she is appointed by the minister in consultation with the chairperson of the Judicial Service Commission and the minister responsible for public service. A person is not qualified to be appointed chairperson of the National Tribunal unless he or she is qualified to be appointed a judge of the High Court. This clause limits the appointment of the chairperson of the tribunal to either a person who qualifies for appointment as a judge of the High Court or a sitting judge of the High Court. In a situation where a sitting judge is appointed, Clause 72 of the bill guides that the appointment of a judge as a person shall not affect his or her tenure of office as a judge, or his or her rank, title, status, procedure, salary, and allowances, or other rights or privileges as the holder of the office of the judge of the course of judicature. And for all purposes, his or her service as chairperson shall be taken to have been service as holder of the office of such a judge. The committee has considered the proposal contained in Clause 72, and it is of the considered opinion that this clause should be rethought in light of the limitations imposed on a judicial officer who serves outside the judiciary under Section 20 of the Administration of Parliament Act. Administration of the Judiciary Act, Cap 4. Parliament Act. This should be judiciary. We shall clarify. Section 20 of the Administration of, it is the Administration of Judiciary Act. The document says Parliament, but it is Administration of Parliament, the Judiciary Act. Section 20 of the Administration of the Judiciary Act requires that where a judicial officer is appointed to an institution outside the judiciary, the judicial officer applies for leave of absence without pay from the judiciary. Section 20 of the Administration of Parliament Act requires that where a judicial officer is appointed to an institution outside the judiciary, the officer requires for leave of absence without pay from the judiciary. The maximum period a judicial officer can serve outside the judiciary is 3 years. This means that a judicial officer who is appointed to the tribunal must apply for leave from the judiciary, and emoluments of that judicial officer are suspended for the duration of his or her service outside the judiciary. Furthermore, Section 20, Paragraph 6, requires that the period of service of the judicial officer outside the judiciary is not counted as part of the judicial officer's service in the judiciary and is discounted in computing retirement benefits. Clause 7 of the bill therefore contradicts Section 20, 1A and 6 of the Administration of the Judiciary Act insofar as it maintains the salary, allowances, other rights or privileges as enjoyed by a holder of the office of the judge of the courts of judicature. Yes, yet these are affected by the provisions of Section 20, 1A of the Administration of the Judiciary Act. It deems the service of the judicial officer outside the judiciary to be service in the judiciary, yet this is barred in Section 20, Paragraph 6 of the Administration of the Judiciary Act. The committee is of the considered opinion that since there is a great deal of backlog in the courts of law, there is need to bar the appointment of serving judicial officers from the tribunal so that the normal operation of the courts is not affected by the appointment of serving judicial officer on the tribunal. Recommendation: in light of the above, clause 7.2 should be deleted and instead clause 3 be amended to bar serving judicial officers from being appointed on the tribunal since it disrupts the administration of justice in courts of law. Transition to the National Tribunal. Clause 41 of the bill provides for transitional matters, and it requires that the bill applies to decisions made before the bill is commenced. Whereas this provision is necessary since it will allow for the filing of the tribunal for review, decisions that were made before the tribunal came into force, it falls short of addressing the issue as to what happens to matters that were filed with the tribunals that are being dissolved, for which the relevant tribunals have not rendered a decision. The committee finds this to be a major stumbling block since at the moment, most of the tribunals that the committee interacted with are grappling with the case backlog due to either delay in appointing members of the relevant tribunals, as the case is with the Tax Appeals Tribunal, or as well as lack of quorum in some other tribunals, as the Electricity Dispute Tribunal, arising from expiration of contracts of the current members of the tribunal. The committee was informed that currently 40 cases are filed with the Tax Appeals Tribunal every month, while the backlog stands at 600 cases yet to be determined. In the case of the Electricity Tribunal, the tribunal has a backlog of over 500 cases arising from non-renewal of contracts of the serving tribunal members, which expired in July. This state of affairs also pertains in other tribunals due to operational reasons. In light of the above, the committee finds the proposal in clause 41 insufficient to deal with the backlog currently experienced before some tribunals, and opines that there is need for the tribunals being dissolved to be given adequate time to finalize all the matters before them for a period of at least 1 year from the commencement of the National Tribunal, so that the National Tribunal is not saddled by the case backlog experienced by the current tribunals. This is advisable for mainly 2 reasons, and we give the reasons. Recommendation: in light of the above, the committee recommends that the bill is amended to provide a transition of the matters that are currently pending before the dissolved tribunals in order to reduce the disruption in delivery of justice that may be occasioned by the dissolution of the tribunals without adequate provision for transitional matters pending before the tribunals. In conclusion, Madam Speaker and honourable members, the committee recommends that the bill be passed into law subject to the attached proposals. I thank you very much, and I beg to move.
Thank you so much, Chair. Chair, I thought you had a minority report. I thought you had a minority report.
Oh, I now take the singular honor to invite my colleague, member of the committee, the Honorable Jonathan, to present the minority report.
Oh, Chitiba. Thank you.
Thank you, Right Honorable Speaker, and I thank the chairperson of the committee for inviting me to present this report. Right Honorable Speaker, this is a minority report in dissent of the majority report of the Committee on Legal and Parliamentary Affairs as provided for in Rule 205, Sub-Rule 1 of the Rules of Procedure of this Parliament. The following are the points of dissent. The first.
Yes.
Madam Speaker, thank you. I'm moving under Rule 204, Sub-Rule 2, which says members of committee making the report shall be collectively responsible for decisions contained in the report and shall not debate. I have seen the name of Jonathan on the main report. A few days ago, the Attorney General guided that a signature of a person is also the name of the person. What that does is to raise questions about the authenticity of the report of the majority. How can you have 2 people, one person sign 2 reports? They're on the majority report and they're also on the minority report. Madam Speaker, under Rule 204, Sub-Rule 3, the rule mandates you to refer this matter to the clerk for investigation so that we establish the authenticity of the report Honorable Baka has been presenting here. Then we will be able to discuss this issue further in the next sitting. So I invite you to exercise the powers conferred on you under that rule to ensure we resolve this matter in a very structured way as dictated in the rules. I thank you.
Honorable Dur, can you present your report?
The first point of dissent under paragraph 2.1, Right Honorable Speaker, is contravention of Article 152 of the Constitution of
I think I'm raising an issue of a question of law.
Yes, I'm saying present the report.
Has an offense been, is that an illegality or it's not an illegality?
Let him present the report.
Idea on what to do.
Procedure.
Do the rules now apply?
Honorable, show me where Honorable Dur initialed in the list of the main report. Initialed. It is talking about initial.
Can I make my case? Rule 204. Rule 204 talks about signing and initial.
You read
and signing according to
2041.
Yes, that's where I am. It says report of a committee shall be signed and initialed by at least 1/3 of all members of the committee and shall be laid on table. I have seen the name.
Is the initial there?
The initial is not there, but the name, according to the auditor, the Attorney General, it is a signature.
What does our rules of procedure say?
It says signing, and signing. Attorney General defined it as the name of the person.
Signing and initialed. Jonathan.
Right Honorable Speaker, just as a rider, usually when reports are presented, I don't want to bring other matters. That's why I confine myself to the text. But I confirm to you that I did not sign the main report.
Listen to
my only signature is on the minority report, and I want to persuade Honorable Lee that the Attorney General is just a lawyer like one of us. He can misguide the House as they have done before many times. On 2.1, contravention of the Article 152 of the Constitution of the Republic of Uganda. The Constitution of the Republic of Uganda is the supreme law of Uganda and shall have binding force on all authorities. In our opinion, includes Parliament and persons throughout Uganda. See Article 2, Clause 1 of the Constitution. Article 2, Clause 2 of the Constitution supra states as follows: if any other law or any custom is inconsistent with any of the provisions of this Constitution, the Constitution shall prevail, and that other law or custom shall, to the extent of the inconsistency, be void. Madam Speaker, Article 152 of the Constitution provides for taxation, and specifically under Clause 3 states, Parliament shall make laws to establish tax tribunals for the purpose of settling tax disputes. The emphasis underlined is ours. It is important to note that in this article, not only commands Parliament to establish tax tribunals, but also prescribes the nature of tax disputes that can be lodged before the tribunal. The deliberate use of the word tax before tribunal signifies the intention of the framers of the Constitution to baptize it as a tax tribunal. The constitutional provision in Article 152(3) can be contrasted with Article 243, Clause 1, which establishes the Land Tribunal and states as follows: Parliament shall by law provide for establishment of Land Tribunal. Our emphasis is that the naming Land Tribunal means you cannot call it by any other name other than a Land Tribunal. The use of plural rather than singular, in our opinion, was deliberate and purposeful to allow flexibility in allowing Parliament create tax tribunals directly or through delegation to address broad geographical coverages, specific category of taxes, as well as appellant jurisdictions if required. For example, a tax tribunal on the subject matter of rental tax, income tax, or broadly customs versus domestic taxes. In geographical scope, the tribunals could be per each Uganda Revenue Authority district office, region, or even at the border entries like Entebbe Airport, Malaba, Busia, Elego, and Motokula, etc. This would allow government to expeditiously resolve tax disputes and free resources involved to the benefit of both the state and the taxpayers. It is therefore critical to note that taxation is an important tool available to the government for purpose of raising resources to deliver services to the taxpayers. The framers of the 1995 Constitution were alive to this fact, and in their wisdom, which we do not have any doubt at all, gave taxation an entire article of its own under 152 with the heading taxation. The majority report in paragraph 2 on page 9 states that Article 152 of the Constitution is in plural and envisages a appointment of more than one tribunal for settlement of a tax tribunal, and further finds the tribunal is not tax appeals tribunal. The minority report respectfully disagrees with this position and finds that the use of the plural tribunals in Article 152, Clause 3, was used deliberately and purposefully to address the different type of taxes such as those mentioned. It is therefore, Madam Speaker, it is therefore erroneous to imagine that a generalized tribunal, such as the proposed National Tribunal, is the one envisaged in Article 152, Clause 3, which sole purpose is to settle tax dispute. The minority report draws the attention of the House to the following paragraphs on page 13 in the majority report. Paragraph 3 states and follows, and I invite members to follow. The majority states the committee has examined the bill and other relevant laws applicable to the subject matter, and it is of the considered opinion that the confusion as to the application of the bill and the proposal to extend the bill to all other tribunals directly or envisaged under the other laws has constitutional and legal ramifications which might affect the legality of the bill if not amended. This is an extract from the majority report. On paragraph 4, it goes ahead to say the first challenge will be constitutional, since clause 42 will have the effect of amending the Constitution to transfer to the National Tribunal the functions of all the tribunals created or envisaged in the Constitution. It should be noted that the Constitution creates directly or indirectly empowers the establishment of the following tribunals. These tribunals have been listed by the majority report. I will not go through, but I invite members to note that from A to H there is a direct mention of an article of the Constitution. This is the difference between the tribunals listed as constitutional and those ones listed by enactment. The only reason the majority report lists those as constitutional tribunal is because the Constitution directly creates or empowers the establishment. The majority report correctly observes that the tribunals, including the Tax Appeals Tribunal, is created or empowered by the Constitution and therefore should be on the list of those protected by the Constitution. In fact, apart from the Tax Appeals Tribunal, it can be clearly seen that those listed from B to H do not have any constitutional citation. The majority report is further contradicted when it listed on page 6 the tribunals created by other enactments, which in their opinion are not protected by the Constitution, to even include A, land tribunals, and B, the Tax Appeals Tribunal. The majority report, having made this observation, in an unprecedented turn, decided to shift the land tribunal as listed on page 6 and included it under item H on page 14 as a tribunal protected by the Constitution, leaving the Tax Appeals Tribunal, which is a constitutional creature, isolated on the list of tribunals created by Acts of Parliament. Our finding: the minority report accordingly finds that the National Tribunal Bill 2024 contravenes Article 152, Clause 3 of the Constitution and invites the House to reject this deliberate position of the majority on the same, which contravenes the Constitution. The second point of dissent is on 2.2, Certificate of Financial Implication. The minority report would like to draw the attention of the House to the Certificate of Financial Implications issued in respect of the bill, to the extent that it only covered the proposed rationalization of the Tax Appeals Tribunal and the Electricity Disputes Tribunal. Indeed, this intention is clearly stated in the Certificate of Financial Implication dated 31st July 2024, and it has been reproduced below. Specific objectives of those certificates: the first is to enable the mainstreaming and rationalization of the Tax Appeals Tribunal and the Electricity Dispute Tribunals, and the public expenditure, thereby inter alia relieving the government of the financial drain on its resources and the burden of wasteful administration and expenditure. 2, to facilitate efficient and effective service delivery by delineating the mandates and functions of the Tax Appeals Tribunal and Electricity Disputes Tribunal, thereby avoiding the duplication of mandates and functions. 3, to promote coordinated administrative arrangements, policies, and procedures for efficient and successful management, financial accounting, and budgetary discipline of the Tax Appeals Tribunal and the Electricity Disputes Tribunal, to enable government to play its proper role more effectively and enforce accountability. And lastly, in 4, to restructure and reorganize the Tax Appeals Tribunal and the Electricity Dispute Tribunal by eliminating bloated structures and functional ambiguities. The main point we are making is that the certificate only talks about those 2 tribunals and not any other tribunal. When it comes to staff laid off and budgetary implications, the 2 tribunals, 11 staff will be laid out. The cost of their terminal benefit, as stated in the certificate, is 2.746 billion shillings. Expected savings and revenue to government: there will be envisaged savings to government of 11.637 billion expected from the merger of the Tax Appeals Tribunal and the Electricity Disputes Tribunal into one national tribunal called the National Tribunal. The savings arises from scaling down the merged structure of the Tax Appeals Tribunal and the Electricity Disputes Tribunal from 46 to 35 staff. I invite members to follow, because the rest of the tribunals allegedly brought here were never assessed in this certificate. What will happen to those staff and the terminal benefits? A patient and critical analysis of the certificate of financial implication issued by the Minister of Finance clearly shows, for all intent and purposes, that it was issued in respect of the National Tribunal Bill 2024 to ration the Tax Appeals Tribunal and the Electricity Disputes Tribunal into a national tribunal. The certificate of financial implication does not mention anywhere the 5 tribunals. That is the PPDA Tribunal, the Insurance Tribunal, the Uganda Communications Tribunal, the Retirement Benefits Appeals Tribunal, the Capital Markets Tribunal, and Seed and Plans Tribunal. All these were not mentioned, and we find problem with the importation. The minority report rejects the legal engineering of the majority report on the basis that Rule 129, Sub-Rule 4, allows the committee to propose amendments as it determines necessary. The minority submits that such amendments are only allowed within the scope of the bill and not matters extraneous that are plainly on the face of it controversial, and therefore invite the House to reject the same and discard it very far away. It is therefore inconceivable that the majority report, without any plausible justification, decided unilaterally, without due regard to the financial implication involved in rationalizing the 5 tribunals, to recommend to the House the inclusion in the bill in what appears to be an attempt at legislative smuggling. Our finding: the minority report finds that the certificate of financial implications issued for the National Tribunal 2024 was issued strictly in respect of the proposed rationalization of the Tax Appeals Tribunal and the Electricity Disputes Tribunal. Dissent 2.3 is inadequate consultation with the key stakeholders. In the process of analyzing the bill, the committee held discussions with only 4 stakeholders that have been listed: Ministry of Justice and Constitutional Affairs, Uganda Law Development Center, the Tax Appeals Tribunal, and the Electricity Disputes Tribunal. The following tribunals, now subject of the bill in the views expressed in the majority, are the PPDA Appeals Tribunal, the Insurance Appeals Tribunal, the UCC Tribunal, Retired Benefits Appeals Tribunal, and the Capital Markets Tribunal. The minority observes that the committee did not interface directly or indirectly with the key stakeholders from those 5 tribunals, despite our considered request that they be invited. On matters of taxation, the key stakeholder is the Uganda Revenue Authority. And Uganda Revenue Authority was never invited for the reasons that the committee was out of time. This reason is self-defeating, since the committee was still well within the 45 days from the time. This is 24th September 2024. The bill was referred to us. In other words, we have 2 more weeks to reach 45 days to have consulted on the same. The minority report emphatically rejects the position of the majority that Cabinet already consulted stakeholders during the formulation of the RAPEX policy. Even if this narrative was to be accepted, it is imperative to point out that Parliament and Cabinet are 2 separate and distinct constitutional institutions with different mandates under Article 79 and 111 respectively. Parliament is reminded of the doctrine of separation of powers as well as the independence it enjoys in the exercise of its function. In fact, several court decisions have clearly stated that Parliament is obliged to consult widely in furtherance of Article 8A. I refer you to the case of Male H. Mabirizi Kekiwanok and others versus the Attorney General Constitutional Appeal number 2 of 2018. Our finding: the minority report finds that the committee did not carry out adequate consultation on the bill, and the key stakeholders proposed to be affected by the bill were not granted opportunity to be heard. Those are the other tribunals listed. 2.4, transitional provision. The majority report observes that Clause 43 of the National Tribunal Bill 2024 proposes to repeal the Tax Appeals Tribunal. This, in effect, terminates the legal life of the Tax Appeals Tribunal and consequently removes from office, Madam Speaker, this, in effect, terminates the legal life of the Tax Appeals Tribunal and consequently removes from office the members of the tribunal. The following provisions for removal from the member of a Tax Appeals Tribunal from office are stated in sections 9, subsection 3 of the Tax Appeals Tribunal Act. A member may be removed from office only for 1. Inability to perform the functions of his or her office arising from infirmity of the body or mind. B. Misbehavior or misconduct. C. Incompetence. And D. Being an undischarged bankrupt. Section 9, subsection 4 of the Tat Act. The minister shall remove a member of the tribunal if the question of his or her removal has been referred to the committee appointed under subsection 5, and the committee has recommended to the minister that the member ought to be removed from office on grounds described in subsection 3. Our finding, Madam Speaker, the minority report finds that the members of the tribunal cannot be removed simply as proposed in the process in the bill as proposed by government, and it may expose government to litigation and financial loss.
Can you continue?
We shall proceed, Madam Speaker.
Madam Speaker, general observation, which is the last. Right Honorable Speaker, before taking leave, the minority report notes that tribunals are specialized courts and are tailor-made for specific purposes, such as the first, removal of office of the following: the president, judges, commissioners, you can extend to others, which is constituted on a case-by-case basis. A tribunal constituted for the purpose of removal of one judicial officer only functions for the purpose of removal of that judicial officer and cannot be extended to remove another person from office. The second purpose of a tribunal is settlement of disputes such as the tax tribunals for the purpose of taxation. Tribunals are meant to offer quick, informal and flexible mechanisms for resolving disputes, and the memberships are carefully selected based on unique skills, experience and expertise. In essence, tribunals are never generalized, as there won't be any difference between the courts of law and the tribunal. A review of all the available literature in the entire world did not return any example of a country with a national tribunal which handles anything and also everything. We now conclude. For these clear reasons, Right Honorable Speaker, the minority report recommends that Parliament does not proceed on the National Tribunal Bill until these findings are addressed. I would like to put on record, Madam Speaker, that this minority report has been duly signed by 3 members, myself, the Honorable Lumu Kizito Richard of Mitiana South, of the Democratic Party, and most of you know I am from the Uganda People's Congress in the opposition, and number 3 by Sekito Leko Robert of Bamunanika of the National Unity Platform. The Shadow Attorney General, Honorable Niwagaba, highly associated but was not able to sign. The same with the Honorable Asan Basalera. In effect, JEMA, NUP, DP, UPC and NRM are part of this. I beg to submit, Madam Speaker.
Thank you so much, Honorable Odur. Honorable members, when you look at the memorandum, you have 2 tribunals. You have the electricity and the tax tribunal. Then when you look at section 42, section 42 gives you, it's more of a supremacy clause. It brings in everything. So I am not sure whether you still want to keep section 42 in this law and move away from your object. That's number one. Number two, the aspect of consultation is also a matter that should be answered. And then the other issue is on the financial implication. Yes.
Madam Speaker, let me try to answer a few issues before the Minister comes in. The first one, Madam Speaker, is on the issue of the tribunals as distinguished between constitutional tribunals and tribunals that we are calling those that are passed by acts of parliament. Madam Speaker, in our report.
Yes, procedure matter.
Madam Speaker, I have been in this parliament for a while. And back, by the way, except last term, I have never seen a report on a bill presented and the minority report is presented. And the chair of the main report proceeds to debate the minority report.
No, he's not debating. I am
even answering.
I have asked him specifics. I have asked him specifics. He's not debating.
Yeah, but Madam Speaker, the reason I said this is strange is that traditionally the presiding officer will invite the House to consider both. But the one of minority comes back now to deal with the minority, yet both of them sat there and wrote their reports. Now you will be inviting minority to come and deal with what is answering. So that's why I said, Madam Speaker, that this procedure we have taken is strange, and I am calling you for your guidance.
I am still asking, how did the section 42 get into the bill when the object had two? That's what I'm asking. I want to know that. How was it smuggled?
No, Speaker, let me localize myself to that specific issue. How the bill had clause 42. We read the bill, internalized it, and it is true that in a memorandum, the bill talks about two entities.
It's two entities.
But when you go into the details of the bill, clause 16 and clause 42 alludes to the fact that all the other issues that will arise under other acts of parliament, where there is a matter that is referred to a tribunal, it will be this tribunal that we are talking about, that we said to. So for that matter, we had to deal with the bill as it was.
Thank you, Honorable Chair. You know, Honorable Chair, we had some debate. When you look, Madam Speaker, at clause 42, that makes reference to all tribunals established under the Acts of Parliament. Some of those tribunals are actually from the Constitution and were operationalized by the Acts of Parliament. In effect, clause 42 intends to amend the Constitution by infection.
Yes.
And even when you look at Article 152 itself, sub Article 3, the majority report notwithstanding, you are amending the Constitution by adding in what the Constitution does not provide. And I believe, Honorable Chair, you should have considered.
Actually, this is like an ad hoc committee handling constitutional matters. Because when you look at Article 69 of the Constitution, it is talking about the Electoral Commission. So this will also handle that. You get it, eh? You look at section 16 also. Look at section 16. Look at section 16. I'm going to allow the debate, but let's first just finish this.
For the clarification, from my senior friend. Madam Speaker, because of that challenge, which my senior friend, Honorable Nwagaba, has alluded to, that's why in the wisdom of the committee, we decided to distinguish those, the tribunals, to exclude those that if we subjected them to this act, they would directly infringe the Constitution. And I can give you the list. For example, if you go to the tribunal for the removal of the member of the Electoral Commission under Article 60, Clause 9 of the Constitution, the tribunal is directly established by the Constitution under Article 69 and Article 60, Clause 9. The tribunal is ad hoc and is appointed by the President. So it is out of our purview. Then there is a tribunal to hear 60, Clause 9. It is appointed by the President. It is out of our purview. Then there is a tribunal to hear and determine a dispute between the Electoral Commission and any person aggrieved by a decision of the Electoral Commission in respect of demarcation of constituencies.
That is on
64, Clause 2. The tribunal is directly established by the Constitution under Article 64, Clause 2. The tribunal is ad hoc and is appointed by the Chief Justice. That one is out of our purview. There is another tribunal to investigate and report to Parliament on the allegation in relation to the removal of the President.
That
if you are
is
impeaching the
Article
President.
107.
Article 107, Clause 4. The tribunal is directly established by the Constitution under Article 104, Clause, and it is ad hoc. And it is appointed by the Chief Justice. That one is also out of our purview. There is a tribunal appointed for the removal of a judicial officer under Article 144, Clause 3 and 4. The tribunal is directly established by the Constitution. The tribunal is ad hoc and is appointed by the President. That one is also out of our purview. There is a tribunal for the removal of the Auditor General under Article 163, Clause 13. The tribunal is also directly established by the Constitution under Article 160. The tribunal is ad hoc and is appointed by the President. That one also is out. There is a tribunal for the appointed for the removal of the Inspector General of Parliament.
Honorable member.
So,
Honorable.
yes.
Honorable Minister, what is hard with you bringing a law with only two, the electricity and then the tax tribunal? Then the other one you bring in constitutional amendments.
There are two issues of contention here. The first one is that the minority report, let me conclude.
You want to appease the President? Thank you, Right Honorable Chair. You know, we had advised the government that if it was to act smart, it would bring a constitutional amendment and delete all those tribunals established under the Constitution. Then come up with a national tribunals bill that will encompass all those bills, including the tax appeals tribunal. You work smarter that way.
Honorable Minister.
Madam Speaker, the Honorable Jonathan Odu, with characteristic ebullience, eloquence, and grandiloquence, has bamboozled many members of this House to run away from the fulcrum of the matter under discussion. The pivot of this matter is rationalization. Sometimes, Madam Speaker, hidden in a forest of words and words that seduce, one can sway opinion, but in reality there is always one or two fulcrums on which something turns, just like a door. It brings to my mind a famous case where a steamship company sued a railway company, saying the railway company, by building a bridge across the river, was undermining business of the ships that moved up and down the river. The lawyer that was acting for the steamship company came and with a lot of verbal artillery addressed court for 1 hour, and then the lawyer for the railroad company came and asked the judge to address his mind to only one issue: whether those who want to move up and down the river have more rights than those who want to move across the river. That was the only question. There was no need for a lot of words. Now let me state the fulcrum. Madam Speaker, the Honorable Jonathan Odu has made it up. Madam Speaker, the leader of opposition should quote the rule under which he is moving the point of order. Because the point of order is about breach of the rules. It is not about your feeling. I will only yield the floor when the Honorable Speaker tells me to yield the floor.
Thank you, Right Honorable Speaker. Ladit, kindly have a seat. Right Honorable Speaker, I firstly want to salute Ladit Mao. He was a guild president of Macquarie, and the flowery language he used then, he's using now. However, Right Honorable Speaker, the concerns, and that is where my point of order arises from. We have raised two critical issues which you have asked the Honorable Minister of Justice to address his mind to. Number one, the fact that this amendment seeks to, by extension, amend the Constitution, which is ultra-vires. It has got no place in law. Number two, Section 76 of the Public Finance Management Act adumbrates very clearly what a certificate of financial implication ought to be. I have a copy of the certificate of financial implication, and as our colleague has clearly stated, it is talking about two tribunals. In your case, you're seeking to deal with many tribunals. That means the certificate of financial implication is defective. Right Honorable Speaker, what you asked Honorable Mao to address us on is those two issues: the amendment of the Constitution by effect, by implication. Number two, the certificate of financial implication. Honorable Mao is taking us in circles. Is he in order, Right Honorable Speaker, to meander as opposed to addressing this House on the two critical issues, two matters of law? And he is a lawyer, Right Honorable Speaker. Is he in order?
Honorable members, when you look at section 16 of the bill, the National Tribunal to review decisions. Any person who is aggrieved by any decision made under this act, subject to review by the National Tribunal, may apply to the National Tribunal for review of a decision, including that of that is a correction of the Constitution. I would request the minister that since there is a drafting problem, so we could have something drafted better, and we will still accommodate you here. I am just requesting that if we could have it taken back for redrafting. Yes, Honorable Minister.
I'm a disciplined citizen of the Republic of Uganda. I'm not immune to logic either. In particular, I'm not immune to common sense. I have strong opinions about those who try to mislead others. But because we have over 46 million Ugandans out there who are interested in having their disputes with the state adjudicated properly, we will pull back for now and come back better and stronger. We will be back. Let the bill be stood over.
Now, Honorable Minister, withdraw it formally.
Madam Speaker, I need some guidance from the chair because our intention was to have it stood over. I will oblige your guidance.
Madam Speaker,
Madam Speaker, there is nothing like standing over a bill.
Madam
in our
Speaker,
rules.
the issues of controversy are very clear to us now. I beg, Madam Speaker, that we stand over and not withdraw. We stand over the issue and reconvene to discuss the controversies.
Honorable Speaker.
Procedure.
The bill is drafted badly. The bill is drafted badly.
Madam Speaker, we would like to thank the House.
Honorable Love, come back to your seat. No, you come back to your seat. No, come back to your seat.
Madam Speaker, I would like to thank the members of the committee for enriching the government bill. I'd also like to thank members of the House, including the minority. The matters of contention are now clear to us. And since you have assured us of time in this House, I wish to move under Rule 140 of the House Rules to withdraw the bill.
Thank you, thank you. I put a question that the National Tribunal Bill Amendment, the National Tribunal Bill 2024 be withdrawn under Rule 140. Those in favor say and the contrary nay. The ayes have it.
Item 4 on the order paper. Bill second reading. The National Coffee Amendment Bill 2024.
Honorable Minister, honorable members, yesterday the bill was was laid on table. It was, the report was presented, both reports. Honorable members, Jonathan, we have finished. Jonah, so the bill the bill on coffee is for the debate. The debate is now open. Yes, Honorable Onzi.
Na msisahau vifijo arrival of His Excellency the President of the Republic of Uganda. Ndio huyo amewasili. Tumpungie mkono.